for all my emails. It's okay. It must be so annoying. Thanks for your help. Sometimes you're not quite sure this one. Who are you sharing the room with? Oh, that's even worse, isn't it?
Good morning, my lord. I appear on behalf of the appellant with my learned junior, Mr Nixon, who sits behind me, and my learned friend, Mr Patrick Lawrence QC, appears for the respondent.
Yes.
My lord, a little bit of housekeeping. There's a core bundle of documents, not too much, a little bit of repetition at the end, but less than you might normally see in the average court bundle. There's the appellant's notice, page 2, the respondent's notice, page 36, and the 3 judgments that have already been given out in this case. One from the Deputy Judge, Mr Martin Griffiths, as he then was, at page 214. One from the Chief Master Marsh, page 128. And then the judgment on appeal from Mr Justice Birss, as he then was, at page 74. My lord, I'm going to try and do this electronically, but I do have a paper security blanket just in case. Can I take your...
Well, you'll find that the court is operating in different ways, as you'll see.
Yes. Well, I'll...
Plugging everything in now.
Resolution your lordship now plugged in.
Yeah, I think so.
My lord, there's a chronology. My lord, there's a chronology at page 70 behind tab 7. There are just 2 other dates that your lordships might like to bear in mind in that chronology. The first is that in 2013, December 2013 is the last time that Zavarco Plc filed any accounts at all. And the other significant date is the 22nd of May 2015. That was the day when Zavarco was delisted from the Frankfurt Stock Exchange and trading in shares was suspended.
Just give me that date again.
22nd of May 2015. Otherwise, that chronology is effectively a chronology of the procedural steps that have taken place in this claim.
Yeah. Yes.
My lord, there's a joint authorities bundle. We were able to put our heads together on that. I hope that was helpful. Passages are marked where we rely on the various dicta. My lords, I'll take matters in whatever order is most convenient to your lordships.
What's the matter for you?
There are 2 principal grounds of appeal. First, that there was secondly, that there was a procedural defect or other irregularity in the proceedings.
That's not really very important, given that you've got permission on ground 1.
Yes.
The only question I've got for you on that is, did you raise your concerns? I forget whether you appeared in front of...
I did.
You did. Did you raise your concerns with the judge on receipt of the draft judgment?
No, the draft judgment, we didn't. The draft judgment came down with the usual sort of Damocles warning that it's not an opportunity to re-argue the case, and it's for clerical, typographical and other such errors only. And we took the view, whether for better or for worse, that that was what was meant by that warning, and we didn't raise it then.
Right. I mean, I don't think that is what is meant by that warning. If the judge is going out on a limb which has not been the subject of submissions, then counsel should raise it. I think there is authority to that effect.
Well,
but I think
we'll put our hands up to that criticism.
Anyway,
we didn't raise.
But the real point is that the issue is before us.
Yes. Good. I think we're left with this state of affairs, effectively, that the respondent appears to accept ground 2, at least in part, but as you say, it doesn't really matter. But the respondent effectively advances again in front of this court what was advanced in front of Mr Justice Birss on appeal from the Master. My Lords, we've set out our arguments at some length in two skeletons, one on our appeal and one in response to the respondent's notice. They're at page 15 and page 62, and I'm not planning on rehearsing what's written there.
Yeah.
Although in one section where we deal with a lot of the authorities dealing with declaratory relief, both domestically and in the Commonwealth, I'm certainly not going to repeat what we've written in our skeleton. I'll just refer your Lordships to it at the appropriate moment. Millennium Friends skeleton is at page 45. That's behind tab 5.
Yep.
So, my Lords, may I just set out a very short background, and then we'll get straight into the legal principles. We say that this case is about a share swap agreement that went catastrophically wrong. We say there's a distinct odour of fraud around the claim for the shares and the money too. The director of Zavarco, Mr Popat Lal, was arrested in Malaysia just a month ago on an allegation he was involved in a bribe relating to the bank loan of 400 million Malaysian ringgit, that's about £70 million, for what was said by the prosecuting authorities to be a non-existent project in respect of one of the companies which sits beneath Zavarco Plc. Mr Popat Lal was released from custody on the 7th of April and is still under investigation along with the bank manager. Tan Sri Nasir, I don't know if your Lordships are aware, Tan Sri is an honorific in Malaysia granted by the King. It's like a knighthood here. Is a well-known and highly respected businessman in Asia. In order to attract business and investors to Zavarco Berhad, that was the Malaysian company, obviously of the same name, he accepted a nominal board position and shares in the Malaysian company, and through his association with the company, substantial interest and investment was generated. Eventually, a decision was made to incorporate what would become a parent company to Zavarco Berhad. It would be incorporated in England and listed on the Frankfurt Stock Exchange. The architect of that plan was Mr Popat Lal. It was implemented by Mr Sidhu with assistance from Mr Popat Lal's advisors. Popat Lal was a registered financial advisor, and so he had to keep his control and interest in the company secret, we say, because he was encouraging investors wearing his other hat to put money into what was effectively his company. The parent, Zavarco Plc, was incorporated on the 29th of June 2011, and it was endowed with 1.2 billion subscriber shares issued at a par value of 10 euro cents each. 360 million of those shares, therefore with a face value of 36 million euros, were allotted to, I'll call him Mr Nasir without intending any disrespect. Mr Nasir's shares in Zavarco Berhad were subsequently transferred to the PLC shortly thereafter, and so far as Mr Nasir was concerned, little happened thereafter. PLC directors came and went, the company stopped filing accounts. We've talked about the last set in existence being for the year ended 2013, and the company stopped filing annual returns. It was delisted by the Frankfurt Stock Exchange, and all trading in the shares was suspended. No one has any idea of the present value of the company, what assets it holds, what cash it may have, or even how this litigation is funded. When previously we asked for security for costs for the appeal, the company was ordered either to provide details of its financial circumstances so that the court could decide whether or not that was a plea well made, or the company could put money into court, and it chose the latter course, thereby disclosing nothing about its own finances. On the 5th of June 2015, a month after the company had been delisted, Mr Nasir received a call notice requiring him to pay Zavarco 36 million euros. And that call notice, it isn't necessary to turn it up, but it's at page 206, tab 16. He refused to pay. He said he'd signed up as a subscriber in the PLC on the basis that he would transfer his valuable shareholding in the Berhad company to the new PLC company. As we might put it, he argued that the share transfer was valid alternative consideration pursuant to the relevant sections 593 to 595 of the Companies Act. Those weren't the words he used. A year later, on the 30th of May 2016, another call notice was issued. That's at page 208. The notice required payment, and warning wasn't made, the shares would then be subject to forfeiture. No payment was made. A few months later, in that autumn, September 16, ZPLC brought a claim against Mr Nasir. The particulars of claim I would like your lordships to look at with me, if that's all right. They're at tab 16, page 172. I'll skip through them quite quickly. Paragraph 3A, it's the bottom of page 172,
Yep.
asserts that the articles bind the company and its members. 3B says that money payable by the defendant, that's Mr Nasir, to the claimant pursuant to the articles is a debt due from the defendant to the claimant and is of the nature of an ordinary contract. Paragraph 4 asserted that Mr Nasir was the holder of shares. Paragraph 5 said that the shares were unpaid and the full nominal value was outstanding. Paragraph 6 noted the call letters and the demand to pay. Skipping on to paragraph 8, there was an asserted failure to pay and that the sums demanded remained unpaid. Paragraph 9 noted the intention to forfeit the shares if the sum of 36 million was not paid. And paragraph 13 noted the response that the shares had been paid for by the share transfer and that a forfeiture would be fraudulent. Paragraph 14 asserted that the directors of the company were entitled to forfeit the shares and noted that they wished to obtain declaratory relief to stop Mr Nasir, I'm quoting, wrongly issuing proceedings to restrain the...
Sorry, where are you reading now?
I'm at 14.
14. Sorry, paragraph 14.
At paragraph 14. I thought it was.
I think on page 175, mine says, in all the circumstances, the claimants are entitled to forfeit the shares. So that, I thought you were going on to read something else.
I have got a wrong reference, but...
I think you were just going on with paragraph 15.
Was that it? I just couldn't...
Which says, as a result of the debtor's
I see, yes.
the claimant is at risk that if it exercises its rights without first obtaining declaratory relief.
That's it. Yes,
Thank
I
you.
understand. Thank you.
No, thank you,
I'm
Milord.
there.
And then we have the claim for relief, a declaration that the shares were unpaid. This is on page 176. Declaration that the shares were unpaid. Declaration about a technicality in the call notice, which isn't important in this appeal. A declaration that the claimant's call notice and or notice of intended forfeiture were valid, and that the claimant or its directors were entitled to forfeit the defendant's shares. Now, a 4-day trial of that action took place in front of Mr Martin Griffiths QC. Zavarco didn't adduce any positive evidence that anyone involved ever intended to pay for the subscriber shares in cash. They didn't call any contemporaneous witnesses at all. Instead, they said that the terms of the share swap couldn't properly be proven and weren't sufficient to displace the default position under the Companies Act. And to cut a long story short, the Deputy Judge agreed. It's fair to say that the witnesses tendered on behalf of Mr Nasir did not cover themselves in glory. There was quite a lot of, if I can put it in inverted commas, confusion in their minds about a document that had been dated. Rather than saying, that was the agreement we entered into on a certain date, but we didn't sign it on that day and we signed it subsequently, they insisted that they had signed it on the date shown on the document, which the judge found to be untrue. I didn't appear in that trial, so I can't give much detail about it other than what we've seen in the judgment. The Deputy Judge found that it hadn't been proven that there was a finalised arrangement to take the shares for alternative consideration. So in other words, that transfer of the shares in Berhad wasn't good enough to pay for the shares that had been given out in the PLC. Sufficient, at least, to meet the requirements of the Companies Act. And what the judge said was Mr Nasir simply didn't concern himself with the question of payment, assuming that it would be sorted out by others, which I think is consistent with the way I opened the case on how he was involved in it. It's paragraph 71 of Mr Griffiths' judgment, if needs be. So the inevitable result for that was that the shares were unpaid. There hadn't been any cash paid and the transfer wasn't good enough to make that good. So Zavarco obtained the relief it sought. A declaration was granted, and the declaration simply stated first that the shares held by Mr Nasir in Zavarco Plc, namely 360 are unpaid, and secondly, Zavarco Plc, having taken the steps required under the Articles of Association, and Mr Nasir having failed to pay for the same, is entitled to forfeit the shares.
Do we have the declaration
Yes,
somewhere?
page 64, my lord.
64. Page? Did you say page 64?
Yes, sorry, that's our skeleton where we set out the
I see.
declarations, and the order itself is at page 247.
That's what I was really looking for.
With the declaration I just read out at 248. It's a
Yes, thank you. Yes. Yes. Yes.
On the 11th of June 2018, his shares were then forfeited. Pursuant to the articles. The articles are at page 180 behind tab 16. Article 69 on page 195. Sets out the provisions concerning call notices.
I'm so sorry, which article was this?
It's, I'm on page 195 in tab 16,
195,
article
thank you.
69.
Thank you.
It's at the bottom of the page.
Yes, thank you.
I don't need to go into the detail unless your lordships would like me to.
No.
At Article 72, there are set out the automatic consequences for failure to comply with the call notice. And 72.1 is probably worth noting. If a person's liable to pay a call and fails to do so by the call payment date, 72.1.1, the directors may issue a notice of intended forfeiture to that person. So in other words, forfeiture comes after a call to pay and non-payment.
Yeah.
Article 74 provides the power to forfeit the shares if payment hasn't been made. And Article 75 sets out the effect of forfeiture, and it's 75.3.4 which has given rise to the second claim. So it's at the top of page 197. Which says, if a person's shares have been forfeited, that person remains liable to the company for all sums payable by that person under the articles at the date of forfeiture. It goes on, in the same manner, in all respects, as if the shares had not been forfeited. So the company gets a double whammy in many respects. Use a colloquialism. First of all, it can forfeit first of all, it asks for the money. If you don't pay the money, then it takes your shares back. Having taken the shares back, it can still ask for the money. So you get neither the shares nor the cash that you paid for them, or didn't pay for them. And there's a provision which says, if we sell those shares on somewhere else, then you get a credit for what we achieve for them. Now, the respondent contends...
So that's where?
That is...
77.
Oh, thank you.
Yes. $77.4. You say yes, I see. Yes, I see. So you get the proceeds of sale, the net proceeds of sale.
Yeah.
Yep.
Now, the respondent contends that at the time of the 2016 proceedings, Zavarco had not taken a final decision to forfeit. When thereafter it did so, it was entitled to sell the shares, says the respondent. The net proceeds of any such resale of the shares would go to the creditor, Mr Nasir, and will fall to be offset against the debt of 36 million. In the event the shares have not been resold, Mr Nasir is not understood to argue that they have value. So that's at page 47, paragraph 4 of Millennium Friends Skeleton argument. But with the greatest respect, that explanation cannot be right. And it can't be right because by the time proceedings were instituted, the company
Well,
had...
I'm sorry. The respondent says that at the date of the, did you say the date of the declaration?
The date of the 2016 proceedings, so September 16.
What,
so
when they
before
were
the
issued?
declaration.
Sorry?
Before the declaration.
But if his assertion, we're not a fact-finding tribunal, so we are not going to resolve any disputed issues of fact. If there's a finding below to the effect that that Mr. Lawrence says, well, that's one thing. There is before us unchallenged evidence, or evidence which has not been challenged at the right time to the same effect, so be it. Otherwise, that's not a fact as far as we're concerned.
No,
so, well, you say it's not been established by any finding. Is there any evidence before us to support what is said by Mr. Lawrence?
I do say that it isn't a finding, and no, there isn't any evidence.
Well, then in that case, we'll wait to hear from Mr. Lawrence about it.
I don't actually put it forward on a factual basis, though. I simply say, as a matter of law, it cannot have been, that cannot be a correct assertion.
I see. I thought you were saying, I'm sorry, I misunderstood then. They said they had not taken a final decision to forfeit.
I can't.
We are about to say because they actually had given a forfeiture notice.
That is factual, obviously.
Yes.
But I say they can't have had that. They can't have not made that decision yet, because by the time those proceedings were instituted, the company was defunct. They weren't allowed to sell the shares anymore. This is a point about giving credit for the sale of the shares which had been forfeited. They could never have given any credit because the shares could never have been sold. Simply as a matter of fact or as a matter of law, it was delisted from the stock exchange before those proceedings were instituted.
Yes, so it's a bit sort of writ in water, really, because it's never going to be of any use. Forfeiture followed by, that there isn't going to be a resale of the shares following forfeiture. They might have said, well, we're just not going to bother to forfeit the shares, we're just going to... they still had a choice whether to forfeit the shares, didn't they?
That's right. That's right.
So why...
Well, so they have to establish the debt first, and of course it's the debt that they're coming for in the second action, because they can't forfeit unless they establish the debt. And then once they've established the debt, they then got a declaration saying we can forfeit. What my learned friend says is, well, we were just doing it in stages because we hadn't decided whether we were going to forfeit or what we were going to do yet. And who knows, we may have had to give credit for, it would never have been 36 million. It was 36 million or such lesser sum as was due. That can't be right by 2016, because the company had already been delisted. Now, as it happens, as I said, in June 18, the shares were forfeited, and in October 2018, a new claim was afoot. And the new particulars of claim are at page 148 behind tab 14.
Sorry, forgive me.
Tab 14,
14.
page 148 of the second set of particulars.
Yep.
We can skip over the first few paragraphs, it's setting out who the parties are. But we then get to paragraph 9, and which asserts that there are some articles. Paragraph 10.1 asserts, as before, that the articles bind the company and its members. 10.2 says, money payable by the defendant to the claimant pursuant to the articles is a debt due from the defendant to the claimant and is of the nature of an ordinary contract debt. Those words, I hope, are still ringing in your lordship's ears from the last time I read them out. From the other set of particulars of claims, it's identical wording. Actually, maybe I shouldn't have skipped over 7 and 8. Paragraph 7 asserts, as before, that the defendant was the holder of 360 million shares, which were forfeited. And paragraph 8 says the defendant's shares in the claimant are unpaid and the full nominal value is outstanding. Again, that's the same wording as before. Paragraph 11 sets out the call letters and the demand to pay. Paragraph 13 asserts a failure to pay and that the sums demanded remain unpaid, and notes that the claimant issued proceedings and this is important, I think, issued proceedings for a declaration that the shares were unpaid. Paragraph 14 sets out the findings in the first trial, and it's asserted that those findings included that the claimant wasn't paid for the shares, that the claimant didn't receive non-money consideration for the shares. It asserted that the findings found that the defendant was required to pay for the shares in cash, that the claimant was entitled to enforce the unpaid nominal value of the shares, the defendant wasn't entitled to relief under Section 606 of the Companies Act, and then by paragraph 17, on page 152, it's noted that the call amount remains unpaid. Your Lordships may remember that paragraph 9 in the first particulars claim had noted the intention to forfeit the shares if the sum of 36 million hadn't been paid. Paragraph 18 sets out the articles again, and paragraph 21 sets out the claim. And it's asserted that the defendant's liable to pay the call amount plus interest. So the claim for interest is new. That wasn't asserted specifically in the first claim. Paragraph 22 asserts the amount outstanding including interest, and paragraph 23 seeks enforcement of the payment of the call amount plus interest. And then we have the prayer, the sum of 36 millions claimed, interest, and then the usual further other relief costs and so on and so forth.
Mhm.
Now, save for recording the findings in the earlier judgment, there are no facts pleaded in the second claim which were not pleaded in the first claim. None whatsoever. There is no relief sought in the second claim which could not have been claimed in the first claim. Indeed, it's a precondition of forfeiture that a call notice has not been answered. When Mr Nasir received this second particulars of claim, he applied to strike out the proceedings on the basis of the doctrine of merger. He said the court has no jurisdiction over me in respect of this claim. So, my lords, I hope that brings me on to the doctrine of merger. The doctrine of merger states that whenever judgment's given in favour of the claimant on a cause of action, that cause of action merges with the judgment, which is said to be of a higher order, and the cause of action is extinguished. The cause of action cannot thereafter be asserted again in order to claim a different remedy or more damages. Only the judgment can be enforced. Now, my lords, we trace the doctrine back just over 175 years to King and Hoare in 1844, but my learned friend helpfully yesterday afternoon found a passage in an earlier edition of Spencer, Bower and Handley, the textbook he relies on, which suggests that the doctrine had actually been in operation since the 1500s. We hadn't found that doctrine going back that far, but now that my learned friends provided the earlier textbook, we will investigate that. Don't think I need to go back further than 175 years for this doctrine, though, and I'll try and make it good just in the last couple of centuries, if I may. King and Hoare was a case about a debt for goods sold and delivered. There was an issue about whether the debt was joint and several, and a procedural issue arose. It was whether a judgment against one of several joint debtors per se, without satisfaction, may be pleaded in bar to an action against one of the other joint debtors. And we rely on what Baron Park said at page 504. It's in the authorities bundle, tab 1, page 7, page 210 of the report.
So it's not a case that on its face raised an issue of merger, is that right?
Well, they were looking at a whole species of res judicata.
But I mean, this was the issue was whether, did you say judgment against one I forget whether you said judgment or payment by or something, judgment against one joint debtor released or was a bar to proceedings against other joint
That's
debtors.
right.
So that's not merger, is it?
Well, they didn't know what it was at that stage. That was what had
Well,
happened.
they may have done, because if it went back to the 15th century, they probably did.
Well,
But anyway, I just want to be absolutely clear as to what, I mean, that was the issue in the case, was it? I mean, that's not to say that what Baron Park said isn't very important. Obviously it is, but I just...
yeah.
Yes.
So it's...
Yeah.
If I've mischaracterised it...
No, it may not have
it's
done
at the
at
top
all.
of page 207, where I think the
207.
procedural issue is
Yes.
set out.
Oh. See, it was Mr. Henderson in support of the demurrer. Yes, but just
Looking awfully good on it, Lord.
anyway, I know I'm sure you haven't. I just wanted to. I was just getting clear
Yes.
in my mind. Anyway,
So then I move on to page 210 in the bundle. It's slightly odd number. Sorry, page 210 of the report, page 7 in the bundle. And I'm looking at the little figures in square brackets, which say 504.
yeah, because that's in the nominate report.
Yeah.
Exactly.
So this is the English report.
I think it must be. mustn't it?
Must be. I think.
Yeah. Okay.
We've highlighted the passage, but I
Yes.
may
Let's just
as
have a
well
look
read it
at
out.
that.
See if I can take
Okay.
your lordships with me. If there be a breach of contract or a wrong done, or any other cause of action by one against another, the judgment be recovered in a court of record, the judgment is a bar to the original cause of action, because it's thereby reduced to a certainty, and the object of the suit attained, so far as it can be at that stage, and it would be useless and vexatious to subject the defendant to another suit for the purpose of obtaining the same result. Hence the legal maxim, transit in rem judicatam. The cause of action is changed into matter of record, which is of a higher nature, and the inferior remedy is merged in the higher. This appears to be equally true where there is but one cause of action, whether it be against a single person or many. The judgment of a court of record changes the nature of that cause of action and prevents its being the subject of another suit, and the cause of action, being single, cannot afterwards be divided into two. Now, we've got a much more recent restatement of that principle, and that's from Lord Sumption in Virgin Atlantic Airways and Zodiac Seats Limited. That was a breach of patent case in which it was alleged that a seat design had been copied, and the claimant in that case, the Virgin Airways case...
I mean, it's interesting to see how Baron Park goes on. Thus it has been held that if two commit a joint tort, the judgment against one is of itself without execution a sufficient bar to an action against the other for the same cause. So, I mean, obviously, damages would be the only remedy for tort. So you have an action, judgment for damages against one tortfeasor bars a claim against another, equally, I suppose, judgment for damages against A, it eliminates the cause of action, so there can't be a further claim for damages against A.
Yes, I mean, if your lordship carries on reading,
Yes.
there's another paragraph which says, we do not think that the case of a joint contract can, in this respect, be distinguished from a joint tort.
No, right.
There's but one cause of action in each case.
Yes.
The party injured may sue all the joint tortfeasors or contractors, or he may sue one, subject to the right of pleading and abatement in the one case and not in the other. So
But I mean, the point I'm making is I'm just trying to see the context of what is being said here. There's no discussion. Is there a sort of choice of remedies? I mean, they're really presupposing a single remedy, aren't they, in respect of the cause of action? So if it's a joint contract, I mean, this was a contract, you say, for the purchase of goods. So you've got a joint liability to pay the price, or you might have a guarantee or something of that sort.
Yeah, the point about this doctrine is that the remedy is by the by.
Well, you say that, but that's the point I'm just taking up with.
Well, I know. I'm trying to...
but but you don't get that out of King and Hall.
It's the starting point, which is...
All right, I see that. Okay.
So our thesis, our submission, our case is that the remedy isn't important. What the doctrine focuses on is the cause of action. the remedy in one sense is irrelevant.
If you go back to what Baron Park started with, I mean, he said it would be vexatious to subject the defendant to another suit for the purposes of obtaining the same result.
Yes.
Now, I mean, the result which was obtained in the 2016 proceedings was a declaration, and that is not the same result as a monetary judgment. So, I mean, that may at least suggest that we're in rather different territory here. It's not a case where you're trying to have two bites of the same cherry, as it's sometimes been put. It's rather a case where your relief stopped short in 2016 at the stage of declaring the rights of the parties, but didn't mature into a judgment which actually meant anyone had to put their hand in the pocket to pay the debt.
Well, I can see why your lordship says that, but rather inexpertly to carry on with the cherry analogy, they bit the cherry before because they established everything they needed to on the cause of action. That there was he held the shares, that they were unpaid, hadn't satisfied the call notice, and they chose whether to have a bite of the cherry or whether to eat the whole thing.
Well, I quite follow. That could get on into, again, my namesakes, Henderson and Henderson territory of abuse of process. But I mean, that I fully understand, but that was considered on the facts and rejected by Mr. Justice Birss, and there's no appeal against his conclusion on that.
Yes, because they aim at different things, the rule in Henderson and Henderson and the doctrine of merger. The rule in Henderson and Henderson looks, for instance, at a broad merits-based approach to all of the surrounding facts. This is a hard-edged piece of law, and which is accepted by my learned friend. And if it operates, it comes down, and there's absolutely no discretion, no looking at the merits or anything else. It's effectively putting into place a policy that that if you've got a cause of action, you have to bring everything that you want out of that cause of action before the court at the same time.
Even if the first proceedings are simply aimed at establishing the existence of the right as opposed to any monetary remedy flowing from it. I mean, that is obviously the logic of your case, and I quite see its sort of force, but it does seem an extraordinarily harsh result in many cases.
Yeah, my lord, there are some harsh results. And of course, in any doctrine, when you get right to the very edges of it, sometimes you think, oh, that's a harsh result. But we'll look at the Indian Grace in a minute.
Well, absolutely, yeah.
I mean, on any basis, that was a harsh result.
Yeah, but at least that was a case where the two bites, well, I mean, sorry, they were both, the first judgment was a money judgment, and arising out of the same cause of action as the second judgment, and that was what was fatal.
That's true, but I think it's scant. I mean, if one went to the owners of the Indian Grace and said, "Oh well, you've got your 6,000. You can't complain about that."
I agree. I mean, well, we're in an area beset with bear traps or pitfalls or whatever, but one doesn't want to have more traps of the unwary than the minimum.
No, and the reason why I say you should stick with me on our hard line of this doctrine is to prevent bear traps for unwary lawyers. Because if you stick with the doctrine as we say it is, everybody knows where they are, and you don't then start blurring the edges by looking at a Henderson point or cause of some sort of estoppel, either issues or causes of action. It's not that; it's a different doctrine. Can I show you what Lord Sumption says about it, and then we'll see whether that brings on the thinking from Baron Park in 1844.
Yes. Right. So that's at tab...
It's at tab 2, page 29.
29, thank you.
Now, as it happens, the Virgin Atlantic case was a breach of patent case where initially what was sought was declaratory relief, but in that same case they also sought damages in the event that the declaration fell in their favour. And that's what we say you should do in a case like this. If you get judgment on the cause of action, you seek the declaratory relief, and then you say, we'll also want damages if we prevail. It's at paragraph 17 of the speeches that we direct your lordship's attention. I can read it, or would it be more convenient for your lordships to read that passage?
No, we'll read it to
yourselves?
ourselves.
So it's page 29 in the bundle, paragraph 17.
Thanks.
Yeah.
So we say the doctrine of merger prevents a
We
successful...
just wanted paragraph 17.
I did, my lord, yes. We say that the doctrine there set out prevents a successful claimant from reasserting his cause of action against the same defendant again. And as I said, it is common ground between us that once the criteria for the doctrine are met, there's no review of the merits of the claim, and there's no discretion. Now, we sought to summarise these different concepts in our skeleton argument at paragraph 21. We said, so far as cause of action estoppel is concerned, that prevents an unsuccessful defendant from denying the existence of a cause of action in a subsequent claim, or it prevents an unsuccessful claimant from asserting that it doesn't exist. It operates as an estoppel to prevent parties contradicting a finding as to the existence or a non-existence of a cause of action. So that's cause of action estoppel, prevents contradiction. Issue estoppel similarly prevents contradiction, albeit on an issue rather than on a whole cause of action. But merger, by contrast, extinguishes a cause of action that's been found to exist. So merger prohibits the reassertion of the same cause of action by a successful claimant, either to claim further damages or to obtain some other remedy arising out of that cause of action. So if the court's invited to prevent a claimant from reasserting a cause of action in which they're successful, that's not cause of action estoppel, but rather a plea of merger is necessary. And so, following it through, we say the question then arises, if merger extinguishes a cause of action, what's a cause of action? Now, my lords, I'm reminded of the infamous opening of an appeal to the House of Lords by the late Leo Price QC. He explained to their lordships that this case is about the basics of contract, offer, acceptance and consideration, which prompted Lord Widgery to comment, Mr. Price, I think you can take it we understand the basics, which then prompted the riposte from Mr. Price, my lord, that was the mistake I made in the court below. Will you indulge me if I address you briefly on a cause of action?
Well, I think it's at the very heart
Good.
of it. It's a good deal less straightforward than offer and acceptance.
Well, that was
It's
a
a pretty
dangerous question, I thought.
elusive concept.
Yes.
It's one of these things we all talk about, but
Yes.
jolly hard to define.
Well, I'm grateful, because had your lordship said no, I would have. It would have been quick, but I'm not sure we would have got to the grist of it. Can we start with Lord Justice Diplock in Latang and Cooper in 1945? It's tab 15 of the Authorities Bundle, page 269 electronically.
Sorry, which tab again did you say?
15 in the Authorities, 269.
I'm afraid I'm resolutely paper-based at this end of the table.
Well, yes, I really was, and then in lockdown 1, I bit the bullet, or bit the cherry, and I'm trying desperately to avoid it, but it's a little uncomfortable still.
Yeah.
It's at 242G, where Lord Justice Diplock, as he then was, talks about a cause of action.
I mean, my recollection is this is usually where discussion of the topic starts. It's and often perhaps it ends as well. But anyway, let's see.
Oh no, we've got more to come.
I'm sure there's much more to come. Yeah.
So, Lord Justice Diplock says, a cause of action is simply a factual situation, the existence of which entitles one person to...
Sorry, you gave the reference
I
here.
did 242G.
242,
I
thank you.
keep looking at that.
Yeah. Yes. Yes.
I hope it's at 269.
Yes, I think it is.
Yes, it is. Lord Justice Diplock, a cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. Historically, he continues, the means by which the remedy was obtained varied with the nature of the factual situation, and causes of action were divided into categories according to the form of action by which the remedy was obtained in the particular kind of factual situation which constituted the cause of action. But that's legal history, not current law. Legal history by 1945. So it's that first sentence we rely on. Cause of action is simply a factual situation, the existence of which entitles one person to obtain from the court a remedy against another person. Now can we move on to Lady Justice Arden's definition, as she then was, in Clark and in Focus Asset Limited. That's tab...
Slightly begs the question, doesn't it? That concise and famous statement. A remedy. So it's a factual situation, but it doesn't help us really on whether
Right.
there might be more than one cause of action leading to a different remedy.
I mean, there may be different causes of action in any particular set of factual circumstances. But what I hope I'm going to show is that it doesn't matter whether the cause of action is in tort or in contract or...
Yeah, but it's interesting, again, just reading on slightly, that B, Lord Justice Diplock says, if A, by failing to exercise reasonable care, inflicts direct personal injury upon B, those facts constitute a cause of action on the part of B against A for damages. So you're saying that you've got on the one hand a cause of action and on the other hand damages. They're separate.
Well, if the Lordship carries on reading, he says the remedy for this cause of action, and then talks about how it's categorised.
Yeah, well, it would be damages in either case, wouldn't it? But it could be in trespass or viet armis or trespass on the case. So, but still a remedy. The remedy is the same. So you can't by. I mean, I'm not quite sure what you're saying there, but my point is only that I'm simply observing that he's sort of referring, isn't he, to damages at that point. Those facts constitute a cause of action for damages.
This was the case of the lady sunbathing on the cliffs who was run over by somebody going to park their car on the cliffs.
Yeah.
And he said,
but I mean,
what he's doing in that passage, my lord, is
Yes.
talking about how pre-1945 actions were categorised. You had to either decide that you were going to sue in negligence, or you had to sue in trespass, or there's a potential assault. Now, what he says is it doesn't matter about the categorisation, because what you're looking at is the causes of action.
No,
We're not focused on the remedy, we're focusing on the...
I mean, in your favour it can be said, because this is in the context of limitation, isn't it? Is it or not?
Yeah.
So-
she was trying to sue in trespass, taking advantage of the longer period of limitation
That's right.
on the same facts.
Yeah.
But
But she was claiming the same remedy.
the point, though, you would make perhaps is this, that if you've got a claim, if there's a claim in negligence, I mean, after all, the Limitation Act still does draw attention to this breach of contract or something. It's all remedies which are barred once the limitation period has expired. So, in order to determine whether there's a cause of action, the nature of the remedy and whether there are two or more remedies and so on is all completely beside the point.
Correct.
Yeah.
And just to address Lord Justice Warby's point, they did seek the remedy in this case that they're now seeking in the second action. They sought a remedy. They sought a finding on the facts that the shares were unpaid. Now, what they could have done is bring a claim for the debt, and then if the debt wasn't paid, they could just have forfeited the shares. They didn't actually need that declaration.
Well, I mean, you're saying this, but I mean, the background as I see it to this case, I mean, we're concerned here with a point of law which is applicable to all cases, but coming back to this case, well, it wasn't the position that your client was saying that this wasn't an issue for cash. This was an issue in consideration of the transfer of shares in the Malaysian company, and I did transfer the shares in the Malaysian company, and there's no liability to pay cash. So that was the sort of the nub issue at that point. Was this or wasn't it an issue for cash, or alternatively, were the circumstances such that the transfer of shares was insufficient to meet your client's liability on the shares? So it was because your client had raised a substantial defence that they sought to establish the legal nature of the relationship between the company and and your client.
They did more than that.
I mean, if there was no issue about whether this had been an issue of shares for cash or not, then one could well see, well, why are you seeking a declaration when all you need to do is seek payment of the funds? But that's not the point really that arose at this stage.
My Lord, it's exactly the point which you raise, and I hope that your Lordship's just made my point for me. In order to get to the point where they could get a declaration that forfeiture was appropriate, they first had to
Well,
have a
can I
determinate...
pause there? There was clearly, it's not so much, was it, a declaration that forfeiture was appropriate. I thought it rather focused on whether, because there were issues about the validity of the call notice that had been given. It was quite a targeted declaration, wasn't it?
Not really. The issue
Well, let's
about
have
the
a look
call,
at
the
it
issue
again.
about
I
the call
thought,
notice had
I
rather
mean,
come
you
out-
showed us the particulars of claim and so on, and we saw there were clearly doubts about, so is entitled to forfeit the shares. I suppose the declaration is made in rather general terms, I agree. But the declarations that were actually sought,
Page 176.
well, thank you. There was quite a menu, wasn't there?
Well, I've seen a
you
lot
know,
worse.
But there seemed to be that maybe I found. I mean, there were. I mean, you could see that it looked to me as if there must be some disputes about the validity of the call notices.
there was
If you look
one-
at C and D, for example.
You're sort of right, if I may be so bold.
Right.
There was a tiny procedural issue.
Well, I
about-
know, but tiny procedural issues can
No,
build
well,
up.
well, if I
Yeah.
were to get to the end of the sentence, I hope
all
I've
right.
convinced you that it really was. It was a tiny procedural issue about whether the first call notice was valid, because a call notice has to run for a certain amount of time before you can be in default of it. The issue was whether they were 1 day out of time on that. On the second call notice, that issue didn't arrive. So, and since it was the second call notice which founded the liability, it really wasn't a point of any substance.
All right.
And in any event, if you go to Mr. Griffiths' order and you see the declarations that were in fact made, there's not even any reference to that procedural issue. It's 248.
The order. Well, no. Well, I'm not sure about that. Is that right? I mean, if you look at the second declaration, it says
Yes, all right. So it's
they is entitled to forfeit the shares. That presupposes there's been a valid call notice, doesn't it?
it doesn't presuppose anything. It determines there's been a valid call notice, and it determines that the call notice has been unpaid, and that the sums were owing, and therefore they're entitled to forfeiture. All of those elements of the cause of action are determined by this order.
Yeah.
Well, the 2 doesn't determine the cause of action. It determines the entitlement to forfeit.
Yes, but you only get forfeiture if you've got shares which you haven't paid for in cash or.
Well, that's the first element.
That you have shares that you haven't paid for, that the call notice has been issued and it hasn't been satisfied.
Yes, but that's the point. There were disputes about that, weren't there?
There wasn't any dispute about the second call notice. No, the dispute was about the first call notice. But in any event, the point I'm trying to make is not looking at the remedy, but looking at the causes of action.
No, I appreciate you're doing that. Appreciate that. And what I'm coming back to you and saying is that the reason, I mean, this doesn't mean that you're not right about your merger, about the effect of merger and so on. But the reason that the proceedings took the form they did is that your client had raised substantial defences to the effect that there was no liability to pay in cash because this was an issue of shares for a non-cash consideration.
It's more complicated than that, my lord, because there was in fact another action brought by Mr Nasir alleging fraud, and there were all sorts of things which needed to be determined. So this was actually a consolidated claim, Mr Nasir's claim and...
So the point was to get all that resolved before one actually got to the point of demanding the money, if you like.
No, the money had
I
been
know they
demanded
had
in-
demanded it, but procedurally the point was to determine all these substantial issues.
I don't think
That maybe has the effect of merger, that's the point, but
I don't
that's-
think I can speculate about why they brought...
well, we can, because we can infer from the nature of the dispute raised and the nature of the proceedings what the real point was.
Well,
I mean,
my lord,
this would look very different if your clients had raised no defence to a liability to pay cash.
my lord, with respect to speculation about why proceedings were brought in this way was also addressed by the Chief Master. And his speculation about why proceedings have been brought in this way was so that the claimant could avoid paying the issue fee on a claim for 36
I saw
million.
that.
Well, the only point I'm making is that I don't know whether the Chief Master was right or wrong, and I don't know with respect whether your Lordship's right or wrong about why they decided to bring the claim in the way they
I'm just putting the point to you.
Yes.
Sorry, just before we leave Latang and Cooper, could I just ask two quick questions arising from it?
Yes.
The first one is, at various points you've mentioned 1945. What's the magic of that date?
Oh, I thought that was the date of Latang and Cooper.
No, it's 1964.
Thank you. I'm sorry.
That's all right.
I'm sorry to have confused your Lordship. I
That's
was
all right,
confused
that's fine.
myself in it.
No, the second point was, I mean, if you read Lord Justice Diplock's definition of a cause of action, I mean, that in itself is too, in one respect at least, isn't it, is too broad or perhaps too narrow, because what about where you have concurrent causes of action in tort and contract? For example, arising out of one piece of alleged professional negligence.
Yes.
I mean, nobody is suggesting that that there's only one cause of action there.
May I get to that?
Yes, of
Because
course.
Lord
If you're
Goff, I think Lord Goff deals with that in
Thank
the Indian Grace.
Yep.
But I hope I will address it.
But
If
the
I haven't,
point
the
is-
Lordship remind me again.
A similar point arises on the facts of this case, doesn't it? Because the majority held that the ingredients of a cause of action in trespass are different from those in negligence, and one of them wasn't present, which was the intentional act, or the intentional act. So that was actually the ratio of the case, I think, probably is that this was only actionable as negligence because it was negligence, not deliberate. Or
Yes,
negligence,
but
not
the point of
intentional.
the
So that makes a point in your favour, I think, because the factual situations were different, and therefore there were two different causes of action.
exactly that.
One of which was statute barred.
Exactly that. So it's the factual situation that's the important bit, not the legal analysis of it. As Lord Justice Diplock said, a cause of action is simply a factual situation, the existence which entitles one person to obtain from the court a remedy against another.
So I think they were all agreed on that. They just differed as to what the ingredients of trespass were,
Yeah.
which we don't need to worry about.
I hope not. If we're in there, I'm in trouble, I think. Or at least I haven't focused your Lordship's minds in the way I hoped. Can we move on to Lady Justice Arden's definition in Clark and in focus asset? That's in tab 3, it's page 50 in the electronic bundle, and paragraph 4. This was a case where the claimants received negligent financial advice and complained to their Financial Ombudsman Service, FOS, under a particular scheme. The Ombudsman had awarded them the statutory maximum of 100,000 in compensation, with a recommendation of significantly more. The claimants accepted the award and then brought a claim for damages for breach of contract against their negligent advisor, accepting that they give credit for the award. And the question was whether the FOS, the Ombudsman award, barred their claim. And what Lady Justice Arden said at paragraph 4 is this: to understand merger, it's necessary to understand the meaning of a cause of action. It's not a legal construct. The term cause of action is used to describe the various categories of factual situations which entitle one person to obtain from the court remedy against another. So it's similar. In fact, while we're here, Lady Arden also describes merger in paragraph 5. Merger, she says, explains what happens to a cause of action when a court or tribunal gives judgment. If a court or tribunal gives judgment on a cause of action, it is extinguished. The claimant, if successful, is then able to enforce the judgment, but only the judgment. The effect of merger is that a claimant cannot bring a second set of proceedings to enforce his cause of action, even if the first tribunal awarded him less than he was entitled to. And finally, and I accept, of course, that this is another case where damages are awarded, which is what gives my learned friend his in to say, well, damages are the key to this. And then page 62 of the bundle, paragraph 77, while we're just in this same report. The judge said, it's sufficient as I see it, that
Is it paragraph
77.
77.
hope it's on page 62. I'll just
Yeah.
check.
Yes.
It is. It's sufficient, as I see it, she said, that the Ombudsman decides a question posed by facts constituting a cause of action. The rationale of res judicata would apply in those circumstances, and none of the authorities shown to us require that the decision in terms decides whether or not a cause of action has been shown or what the party's legal rights or obligations were. In my judgment, it's sufficient that he decides whether the facts underlying a cause of action give rise to any claim as between the claimant and the advisor. So we're not focused on remedy, we're focused on the facts underlying the complaint.
Would that be so, even if the Ombudsman had made an award which was actually expressly not based on any legal entitlement, but rather on a sort of broader considerations that an Ombudsman is permitted to take into account? I mean, it would seem extraordinarily hard that an Ombudsman award on that explicitly non-legal footing should nevertheless trigger the operation of merger.
I think what you need is a judgment on a cause of action. And so there has to be a determination of the facts giving rise to that cause of action in order for the doctrine to work or to come into play. And so if there has been a determination of the facts giving on the cause of action, then the doctrine bites. I mean, we see this a lot in practice where there are statutory regimes for review of usually financial services things, one makes a choice with the client about whether to go to the Ombudsman, which has a ceiling,
Yes.
or whether to go to court and without the ceiling, but perhaps with cost consequences. And you choose. What you don't do is go to the Ombudsman, get what you can from the Ombudsman on a free ride, and then see whether you want to have another bite of the cherry in front of the court. Now, we don't see many cases of merger, and it may be that one of the reasons for that is that lawyers know that you only get one chance to put your case before a court or tribunal, a court of record, as it's put in the order of authority.
Maybe the couple of sentences at the end of that paragraph assist your case. She says that if that conclusion means that if the complainant were unwisely to accept an award offering him only an apology, res judicata, I want to come back to that, would apply if he chose to bring court proceedings, presumably for some, for example, monetary remedy. But this is all put in terms of res judicata.
Well,
She has earlier, has she distinguished between the two?
this was decided.
Is she?
Is this a case that was heard after Zodiac but without reference to it? Or,
I'm sorry, Malone, I didn't quite...
I'm sorry, is this the case that was heard after judgment had been given in the Zodiac case but without any reference to it?
Yes. Yes, there's a peculiar... all of the authorities don't... It's not very good that we don't have this string of authorities which traces everything all the way through. It seems that each case is sort of decided on its own facts. It's not to say they're sui generis at all, but nonetheless, there isn't citation of these.
I mean, I make this point in the light of what Lady Justice Arden says in paragraph 3 of her judgment. So she's distinguishing. She says there are two principles at work. One is res judicata and one is merger. I don't read her as saying they're simply synonyms.
No, they're not. And indeed, Lord Sumption draws that distinction.
Right.
Between...
So at any rate, she is looking at this as a question of res judicata rather than merger.
Well, she's looking absolutely explicitly at merger, but in fact...
Well, no, she's not. At 77, she's basing it on res judicata, isn't she?
The ratio and the decision in this case relies on res judicata, but she's looking at the law on merger.
Well, I know, but all I'm saying is, how far can you rely on paragraph 77, given that that's a discussion of res judicata and its application to this case, when she has herself distinguished the two principles?
Well, I'm not saying that you are bound. This court is bound to accept what Lady Justice Arden.
Well, I mean, so far as 77 is concerned, she's simply not addressing merger, is she?
Can I come back to that? I just want to
Yes.
check that she hasn't elided the different concepts of res judicata. and
Well, she
merger,
didn't
which
in
is-
paragraph 3. I mean,
I
she
agree.
treated
agree.
them as separate.
I'll need to.
See.
May I
All right.
have another look at that?
Yes, certainly. I think, judging from it, maybe that I think Lord Justice. I think I remember something in one of your skeletons, maybe in your skeleton actually, where I think Lord Justice Davies said it didn't really matter which doctrine you applied. I don't have that reference. He gave a short concurring judgment. But anyway, there we are. We want to come back to that by all means.
Perhaps that's 125. He says, I don't think it material for present purposes.
Yes, and Malone Juniors has pointed out 126, which
Yeah.
I'm just turning up.
Yes.
On murder, she has something to say, Lady Justice Arden, in paragraph 7.
Yes.
Paragraph
Paragraph
it's
7.
less demanding than res judicata. in a sense.
I see. I mean, I suppose, really, I mean, I'm slightly surprised that Lord Justice Davis refers to merger, because it's difficult to see how an award, how a cause of action can merge into an award by an ombudsman. I mean,
Why?
well, I mean, well, if one goes back, I mean, the whole notion is it's a judgment of the court. It doesn't not relate to the particular position of a court. Rather, I may be wrong about that. Of course, does an arbitration award create merger as well?
It does.
Yes,
yeah.
all right. Yes. Well, okay.
And under this scheme, as I understand it, I'm not familiar with the scheme, but it's the acceptance of the award that is critical.
Yes, because it's non-binding until the point of agreement.
Yeah. Well, he says, I see, that, yes, I see. So Lady Justice Arden says this case is concerned with cause of action estoppel. Yeah, okay.
But my lord, you're right also to be. I mean, in days of yore, it not only had to be a judgment from a court, but dirty foreign judgments weren't accepted
Well,
at all.
that's hence the act. Yeah,
Hence the act.
Yeah.
And so we've moved on slightly
Yeah.
from that position.
Yes, yes.
Now.
All right. Okay, well, thank you for that. Yeah.
So we're still. I'm still on the definition of a cause of action.
Yes.
And may I now turn to British Columbia for some help? Wolverton Securities and Schemmel. It was a case. It's in tab 16, page 276. It was a case concerning the reassertion of a claim around the defendant's bankruptcy, and the judgment was given by the Honourable Madame Justice Birss J. Brown. It's page 286, which I want to turn to, paragraph 42. So 286 is the electronic numbering.
Yeah.
The cause of action, says the judge, is the combination of facts which gives rise to the right of action by a party against another in the first action. Because a party frames a first action in contract and the second action in tort, does not change the determinative issues which the first court decided and which the second court would be asked to decide again, but with different remedies as the objective. That is, for example, restitution rather than damages, or perhaps bringing it closer to home, money rather than shares. A new legal theory in a second action such as tort rather than contract, marshalling the combination of facts from the first action in a different way, will not create a separate and distinct cause of action. I always have my heart in my mouth in case my Lord David Richards goes and looks further down the authority.
That's always no. Don't worry.
So can I sum up a cause of action this way? it's not a legal construct, but rather a combination of facts or a factual situation which entitles one person to obtain from the court a remedy against another person.
So it's a combination of facts.
Or a factual situation which entitles one person to obtain from the court a remedy against another.
And in your formulation, a remedy means any remedy.
It does.
To adopt Lady Justice Arden's way of putting it.
It does, yeah. So as long as the cause of action entitles a claimant to ask for relief, the law requires the claimant to claim that relief once and for all. That's what we say about it. And as we looked at the two statements of case and the two claims in this case, our submission is that the combination of facts in the first claim, which entitled the claimant to obtain from the court a remedy against the defendant, is exactly the same as the combination of facts in the second claim, which would now entitle the claimant to obtain from the court a remedy against the defendant. And we say the doctrine of merger doesn't allow that. We do acknowledge in paragraph 25 of our skeleton that the application of that doctrine can have stark results, and that brings me on to the Indian grace.
Is it another way of putting it that, and therefore, the result of merger is you cannot sue twice on the same cause of action?
Absolutely.
Yeah. I mean, that's just spelling out the consequence of extinguishing the cause of action, but that's in practical terms what it comes to.
Exactly.
Yes, okay. So the Indian grace.
Yes, so it's at page 74, tab 4 of the authorities manual, page 74.
Yes.
And we mark a passage from 418. What had happened was that a fire broke out on the defendant's vessel. Part of the consignment owned by the claimants was jettisoned, and the remainder was delivered in damaged condition. The claimant successfully brought a claim in Cochin, India, in respect of the jettisoned cargo for non-delivery. That was a claim worth about £6,000. They then brought proceedings in England in respect of the damaged cargo worth about 2.6 million. Now, for my purposes, we can start at 419F in the report. It's page 83 in the electronic version. And I said we'd get on to Lord Gough. This is the speech of Lord Gough. He says, the argument, this is at 419F, page 83. The argument advanced by the plaintiffs before your lordships was that for the purpose of ascertaining whether there was identity between the causes of action in the two sets of proceedings, a distinction had to be drawn between an action for damage to cargo and an action for short delivery. The submission was that, in accordance with the principle stated by Lord Justice Diplock in Latang and Cooper, the cause of action consists of the minimum facts which a plaintiff is required in law to plead, and, if traversed, prove in order to obtain the relief which he claims. Now, pausing there, the minimum facts which had to be pleaded in the first claim, in our case, were that the claimant held the shares, he'd not paid for them, a call notice had been issued, which was unsatisfied, and therefore the company intended to forfeit the shares. Now, in order to obtain the declaration that the claimant sought in the first action, they had to plead the minimum facts necessary to obtain the relief they seek in the second action. They set out their cause of action.
Sorry, are you reading from Lord Gough?
No, I'm not. I'm talking about our case.
Right, okay, sorry. Right. Yes, I was...
You were thinking this
Well, I
this
was
is
just
remarkable.
interested to know what Lord Gough's answer is to the submission made.
Well, I'm going to get, it's at 420F. Delayed gratification, my lord, is worth it.
Okay.
I hope. Can I just make the point I'm trying to make?
Well, I think I understand the point, because you've made it already, I think, is that the same facts are pleaded in both sets of proceedings.
Yes, well, that they're necessary. They're the minimum facts necessary.
Yeah,
The cause of action.
absolutely.
So let's wait no longer. 421E at page 85 in the bundle.
Right.
Lord Gough says there's no need to distinguish between the two breaches because the factual basis relied upon by the plaintiffs as giving rise to the two breaches is the same, and indeed was referred to compendiously by the claimants in the coaching action as negligence. In these circumstances, I'm satisfied that there is identity between the causes of action in the two sets of proceedings. Now, we did touch very briefly on Section 34 of the Civil Jurisdiction and Judgments Act, which Lord Sumption describes as creating a corresponding rule to merger in respect of foreign judgments. And that provides that no proceedings may be brought by a person in England and Wales or Northern Ireland on a cause of action in respect of which a judgment has been given in his favour in proceedings between the same parties or their privy in a court in another part of the UK. So the governing principle is whether a judgment has been given on a cause of action between the same parties. If so, no further claim can be brought on that cause of action. Now, the Chief Master agreed with that analysis and the analysis of the doctrine I just set out and determined that the causes of action in the two claims were identical. And he dismissed the idea that the form of relief claimed in the first action should somehow prevent the application of the doctrine. So what happened on appeal then? Why are we here? The company appealed to the High Court on three bases. First, that the 2017 judgment was purely declaratory. And as a matter of law, it was said, it's not possible for a cause of action to merge in and be extinguished by a declaratory judgment. That was their first point. Second, that if a cause of action held by the claimant did merge into the judgment, it was a different cause of action to the one brought in the second claim. And then there was a ground about cumulative remedies, which nobody had to look at any further. Mr. Justice Birss allowed the appeal and set aside the Chief Master's judgment, but he did so not on those bases at all. Indeed, on those grounds, he agreed with us completely. We addressed what happened in paragraphs 29 to 33 of our skeleton, and the judge adopted this new lexicon of rights, which we criticised. But he didn't accept the company's arguments on appeal. At paragraphs 23 and 24 of the judgment, it's page 79 in the volume behind tab 9. Page 79.
Yes.
At 23 and 24, he said, I agree with the Chief Master that it shows that declarations can qualify as judgments granting relief, and therefore shows that the justification in Spencer, Bower and Handley for why declarations cannot support merger is, at least, too widely stated, in that it treats all declarations if they're not relief or not capable of being a remedy. In my judgment, this case illustrates that a declaration can be a remedy for a cause of action, and since it can be, there is no reason why the doctrine of merger could not apply when it's the sole remedy granted. A declaration is a remedy which the claimant can recover, to use the word stressed by the company, based on a cause of action. In that, I agree with the Chief Master. Now, on the second ground, the judge didn't have to decide the issue, but he did deal with the point at paragraph 33, that's at page 80. Sorry, it's not at page 80, I've got that. Oh, sorry, it is. It's page 80 of the core bundle, not the authorities bundle.
Yep. Yes. I mean, this is the one where he ends up saying that he doesn't have to decide it, but he sees force in the Chief Master's decision.
That's right, yeah. Exactly that. And so we say where the judge went wrong was in the reframing of the doctrine of merger in paragraph 12 of the judgment, and then in paragraphs 27 to 31 into this concept of rights. The judge found that Zavarco's right to forfeit the shares had merged into the 2017 judgment, but that was not the same as a right to 30 million odd in debt, and therefore merger did not apply, and Zavarco could bring a claim to assert its new rights. And that's why we say this concept of the rights theory, as we've termed it, there's no magic to that.
I'm trying to understand in the light of what he said in 23. to 24. He accepts in 24 that there's no reason why the doctrine of merger could not apply when a declaration is the sole remedy granted. But he then goes on, and you're coming to it or dealing with it now. I know the basis for his decision that the rights-based approach. But if a declaration can form the basis of merger, I'm just not following how the rights-based approach arises, unless he's saying that there are sort of two different categories of declaration depending on the circumstances of the case.
No, he didn't.
Like
there are different categories of declaration. I will come on to that. But
right.
They're not different categories. They're just different things.
Okay.
It's declarations.
Right. So,
broad.
all right. Yes.
But that's why we say he went wrong. I mean.
All right. Well, I'm sorry. I cut you off. So it was paragraph.
Well, 12 is where he
12.
sets out his. I don't mean this in any way disparagingly, but his theory about rights.
Okay, this is in 12. We see this in 12, do we? Because
yes, page 76 of the call.
This is the one where if you've got one award of damages, you can't have another. Is that it? Or what award of money?
Well, yes. I mean, the way we put it, this is where the judge's lexicon or taxonomy or we want to put it goes wrong. And indeed, he says in the final sentence, whether merger is the best metaphorical description of this idea doesn't matter.
But yes.
So I mean, we're in curious grounds here.
It's, this is an entitlement to damages for breach of contract. That's the example he's taking? Is that right?
I can't honestly say I fully understand the language.
All right. Well, let me have a look. Yes, here we are. So he's taking as an example the claim for breach of contract. I think that must be probably a claim for damages. I don't know.
He seems to be treating a cause of action as a right to obtain a specific remedy.
Yes, I think so.
A set of facts that gives you a right to obtain a specific remedy. So the remedy is part of the cause of action. So you can have a cause of action for damages and a cause of action for an injunction and a cause of action for a declaration and so forth.
Yes,
and I think in some systems of law that's how it works.
I think that's right. And what we say, the criticism we make, is that you move away from all of those definitions or explanations of what a cause of action is to something which sits on top of a cause of action, which is what relief you might seek arising out of that cause of action. For instance, that trespass claim or the negligence claim, so on and so forth.
Yes, okay. I mean, this is actually more than an illustration, in other words. I mean, he starts by saying that this just illustrates what merger is about. Well, I mean, it is an example of merger, what he gives, and one which is readily understandable. But you're saying, I mean, what you say actually is that he's sort of not only merger here, but defining it by reference to this.
He must do,
right?
Because he finds against us in the end.
Yeah, well, let's see how he gets there. In the light of that.
So the 27 to 31, I think, is where
27 to 31
is where we start spiraling towards the earth. Shall I leave your lordships just?
Yes, we'll just read through that. Thank you.
So is he saying that what did merge was the right to claim a declaration and nothing else?
I don't really know. Is the honest answer to that question?
He's certainly saying that what didn't merge
He's,
is the right, the right to recover the money.
yeah, yeah, he is.
So he says something merged, but not the money, not the right to recover the money.
We've tried to
Or
on
not
this
the
side,
right to sue for the money, I should say.
yes, and we've tried to define what the judge was saying. We've called it the rights issue. My learned friend says that's a straw man and it's easy to knock down, but it's not entirely clear to me, and this is no criticism of my learned friend, but it's not entirely clear to me what they say the judge decided. I think my learned friend suggests that Mr. Justice Birss didn't apply the rights theory at all, but it's said by my learned friend that he adopted an implicit position that declarations could merge a cause of action, but only exceptionally. It might not matter, my lords, whether the rights theory is the correct analysis of the judgment, or it's a straw man, or whether there's some more substantial sort of man lurking elsewhere. But
Yes, I mean, I think what he's saying is that the claimant company had a legal right to the payment of cash on the shares, for the shares to be paid up. And the declaration stated that right existed, but didn't give effect to it. And that therefore the right remained to be enforced.
right.
That
That sounds pretty plausible.
And I think that's the point he makes in 26, isn't it? I mean, which to me has a certain common sense attraction to it. He says, I don't see how a declaration which declares declares to exist the right which the claimant already had before judgment was given, could be said to extinguish that pre-existing right. It does the opposite.
Well, the right question is not strictly whether one has a cause of action for a declaration or a right for a declaration.
Yeah, exactly.
The question is whether the declaration is on a cause of action.
Yes, and I do see that. Yeah.
And so that is whether the findings on past fact justify the grant of relief, entitling you to relief. And if the declarations are based on the same facts and matters that form the basis of a new claim, they can't be reasserted. That's what the doctrine does. So, and the Chief Master put it quite nicely. He said, a declaration that is based upon findings of fact that relate to a recognisable cause of action still determines the issue. And it's hard to see why it should not have the effect of extinguishing the cause of action. That's what the Chief Master said at paragraph 46 of his judgment, page 140. And when my learned friend says, well, you know, it has to be different. It has to be a coercive judgment in order to activate this. We say that's not right. And he says, well, you don't get anything when you get a declaration. But that's not right either. They did get lots when they got it. They got a determination from a court that the shares were unpaid, that the money was due and owing, and indeed they got a right which we could not reassert in a court of law, saying, no, you're wrong about that. You're not entitled to forfeit. And we say that argument is a distinction without a difference, both in
So you say the declaration gave them, what did you say then?
It gave them valuable things. It gave them a judicial determination that the shares were unpaid, that there was a debt outstanding, and that they were entitled to forfeit. So we say a court judgment declaring the right to forfeit isn't just a confirmation of an existing position. It's a powerful tool.
Well, surely it is just a confirmation, but that's what makes it powerful, because the court is saying so.
Yes.
I'm not going to argue much about that. But it's a final binding determination of the legal position and prevents reassertion by us of that proposition. And the reason
would mean, for example, that the company could have presented, I mean, leave aside jurisdictional issues, could have presented a bankruptcy petition.
Absolutely.
Yeah.
And the reason Zavarco sought the declaration was precisely because a final declaration was of a higher order, to use the old language, than an undetermined right to forfeit.
Yeah. What makes the case seem particularly on an intuitive level difficult to swallow is the fact that you go to all this trouble to get a declaration which clears away all the defences which might lie in the way of your seeking to recover the money unpaid on the shares, only to be met with an argument saying, ha, you can't recover a penny now, just because you didn't put in a further paragraph in your particulars of claim saying, and the claimant claims whatever it was, so many euros.
I know.
I mean,
I do know that.
It just feels wrong.
I know, and I bet it felt wrong to the owners of the cargo in the Indian Grace as well.
Yes.
And I hasten to add that there is another trial of Zavarco and another shareholder who hasn't paid, where the particulars of claim do claim precisely that relief as well in the one claim.
Just to rub salt into the wound.
Well, I mean, perhaps one's bitten twice shy.
Well, indeed.
I mean, yeah.
I've lost the original particulars of claim, but didn't they claim further or other relief, which of course is standard form, but actually can mean something?
They did, and we actually addressed that in front of the Chief Master, who said, no, it doesn't really mean anything. I'm being slightly glib about what
He did address it, didn't he? I think I picked that up. Anyway, that's not before us. No. Right.
So we said the only plausible reading of the judgment is that cause of action were found by the judge not to matter, and it was rights that determined whether or not and that was not right, that was wrong. And we've set out in our skeleton argument at length 6 domestic authorities, 5 of which were binding on the judge, whose reasoning is entirely incompatible with any rights theory. And mindful of the help Lord Justice Diplock said he gained from Commonwealth authorities, for good measure we've cited 3 Commonwealth cases too.
Yep.
I'm very happy to go through all of those in my skeleton, but I don't have anything else to say about them other than what I've written. So shall I give your lordships the reference to it?
Well, we've got for the authorities.
Yes.
Well, they're in your skeleton.
They are.
Say,
So just paragraphs 35. I mean, it's
we've
35
listed through it. Oh, I mean, I've read through it. I haven't looked at the authorities, but I will do so. Obviously.
35 to 54 in our skeleton, page 24 in the e-bundle. And perhaps I'll just reserve the right to respond if my learned friend deals with any of them.
Just are there any? There are no authorities. Is this right? Where the relief claimed and obtained in the first action was a declaration. This is this in this sense virgin territory?
Well, it is virgin territory because in Virgin Atlantic,
Yes.
that was a case where a declaration was sought and then damages sought in the.
If they got their declaration,
Yeah.
I think you told us that.
But other than that, no. That's right.
Well, I mean, I've looked at Virgin before, but I can't remember now. It wasn't actually a merger case, is that right? Or was it?
No, it wasn't. No.
No, I mean, Lord Sumption was sort of looking at the landscape, as it
Yeah.
were.
I mean, Lord Sumption was counsel in the Indian Grace.
Oh, was it?
Yes, I saw that.
I see. I hadn't seen that.
As it happened.
And Lord Gough goes through all the authorities that you've referred us to, King and Hoare and so on, doesn't he? I haven't looked carefully at that.
I
yet,
couldn't
but-
swear that it's all of them.
No,
yes,
but
they
I
certainly,
see.
they certainly are.
But it's a
referenced,
sort of, yes, I say Lord Sumption he'd done the work before, yes.
Well, he was unsuccessful.
Yeah, oh,
So
well,
he was trying to say he wanted another bite of the cherry.
Yeah.
He was told no.
yes,
Um,
And learnt his lesson.
Yeah.
Um,
Yeah, but then didn't decide once he reached the Supreme Court that he was going to be vindicated, revenge being served sometime cold. He said no, actually, Lord Gough was right about it. So we say merger applies to causes of action. It's not concerned with the relief. Cause of action is the combination of facts giving rise to a legal right. It's not the right itself. The combination of facts giving rise to the rights of the present claim and the 2016 claim are identical, and because the causes of action are identical, the doctrine of merger applies. So I've got one final, I hope it's a final section, about whether the nature of the relief affects the doctrine. Or if that would be helpful.
yes, certainly.
So the respondent argues that the judge made a different error in this case, that as a matter of law, it's not possible for a cause of action to merge in and be extinguished by a declaratory judgment. Now, the only support for that proposition comes from a passage in a textbook, Spencer, Bower and Handley. Several versions of the textbook all say the same thing or substantially the same thing. It's in the authorities bundle at page 250. Now, my own friend spent some time talking about former recovery and the index to the textbook. Former recovery is a term of art not known outside this textbook.
Right.
Unless it's in the 1500s authorities, which I'm afraid I have to admit we did not delve into. He relies on 20.1, where the authors say the following do not qualify as a judgment granting relief for present purposes, a declaration of right.
Oh, it's down at the bottom of the page. Yes.
I'm sorry that this is landscape. It's the
No, don't worry about it. I'm just locating it. That's all. That's got it now. Yeah.
And at 20.8, the authors continue, the former recovery must be a final judgment capable of supporting an action. Other final judgments which will support a plea of res judicata estoppel, such as declaratory judgments, will not support this plea. Now, with the greatest of respect for these authors, there is neither reasoning nor authority to support those propositions.
What does the former recovery must be a final judgment capable of supporting an action on the. What's meant by that? An action on the judgment.
Well, I think this is my learned friend's point. I think
Yes.
Rather
Yeah.
he developed it,
No, I understand.
and I responded.
Yeah. 502.
I mean,
Yes.
on the face of it, though, I mean, why is a declaration not such a final judgment? And if you basically you sue for the money and you rely on the judgment that's already, or on the declaration already binding between the parties, which establishes your right to the money.
Well, Lord, I really hope that you asked my learned friend that question. I can't see any reason to parse it in the way that my learned friend does. Declaratory relief is varied in its scope. Many declarations won't be based on a cause of action. That's a combination of facts on which a legal right may be based, because they perform other functions, such as to create legal certainty into the future before any cause of action giving rise to a right has arisen.
Yeah.
And a declaration of liability, for instance, in a split trial might have been what the authors had in mind here.
Yeah.
But we say that's obviously not a remedy on a whole cause of action. I mean, the court will be achingly familiar with the wide variety of circumstances in which declarations can be given, and the Chief Master did deal with this point at paragraphs 45 to 47 of his judgment. He said, however, declaratory relief arises in many different circumstances, and in some cases it's not obviously based on a readily recognisable cause of action in the Latang and Cooper sense. For example, a declaration as to status, the lawfulness of a decision or a future course of conduct, are rather different to a declaration that a debt is due under a contract. By contrast, for the court to grant a declaration that a liquidated sum is due under a contract, it must have considered and determined all the facts that form the cause of action. The exercise the court's undertaken to reach the judgment is the same as if the claim had sought judgment for the liquidated sum. The position might be different if a declaration were to be sought in terms that the defendant was in breach of the provisions of a contract without seeking further relief, even if damages are not an essential part of the cause of action. The point doesn't arise here because the claim is for a liquidated sum, the essential elements of the cause of action being the obligation to pay and non-payment. The essence of the doctrine of merger, says the Chief Master, is that the cause of action merges in the judgment. The cause of action is thereby extinguished by a combination of the judicial determination of the facts forming the cause of action and manifestation of that determination in the order or judgment of the court that follows. Even accepting that a declaration does not have any executory or coercive effect, a declaration that is based upon findings of fact that relate to a recognisable cause of action still determines the issue, and it's hard to see why it should not have the effect of extinguishing the cause of action. It is, after all, a matter for the claimant to decide whether the additional relief may be needed. It seems to me, said the Chief Master, with respect to the authors of Spencer, Bower and Handley, that whether the granted declaration will lead to a merger depends upon the nature of the claim and the declaration that's granted. Now, the declaration in this case resulted from a 4-day fact-finding exercise determining past facts on the balance of probabilities, and those factual findings gave rise to 2 rights. Chronologically, a right to 36 million, and, if unpaid, a right to forfeit Mr Nasir's shares. Now, Zavarco only claimed one remedy, a declaration. The findings on the cause of action, the combination of facts entitling a party to seek a remedy from the court, were that the shares were unpaid and that the shares could be forfeited. The declared right to forfeit depended on the precise same facts as Zavarco's entitlement to debt. So the cause of action is identical, and there's no principled reason for the merger doctrine not to apply. Now, the respondent seeks to get round that problem by changing the terminology, as Lord Sumption would put it, changing the label to obscure the contents of the bottle. The learned friend says that for the doctrine to operate, the judgment may be one granting recovery, relying on the reference in the textbook to form a recovery. And I did say earlier, in response to your Lordship's questions, that the relief granted in this case was substantial. It entitled Zavarco to forfeit 36 million euros worth of shares. Over £500,000 of costs were incurred in order to obtain that declaration. So if there is a requirement for recovery, quod known, it was met. The second rider, my learned friend seeks to put on the doctrine, is that a judgment needs to be executory or coercive, in the sense that it's something that can be directly and positively enforced. But that's just another way of excluding declarations, a proposition which, as I've said, for which there is no support. And equally, there's no basis for the statement that the doctrine of merger is a rule against double recovery, which is what my learned friend says in his skeleton argument at paragraph 25. The claimants in the Indian Grace would certainly object to that proposition. They'd advanced the claim in India for £6,000 for the loss of jettisoned cargo after a fire, but they're prevented by merger from bringing a further claim for millions in respect to an entirely different cargo that had been fire damaged. There wasn't a risk of double recovery at all, but the doctrine applied with full force, albeit under the judgment, Civil Jurisdiction Judgments Act. And that's because the doctrine is about the reassertion of facts and not about the recovery at all. So ultimately, the introduction of an exception for merger would be unsupported by previous authority, and we say it would undermine the balance of interest that the law has struck. And it would also mean, if you accept what my learned friend says, that a difference is reintroduced into English law between judgments in England and Wales and foreign judgments, which the Act sought successfully to prevent. Because there's no room in the statutory language for a carve-out for declarations. And the doctrine also reflects a policy that neither litigants nor the court should be vexed repeatedly by the same cause of action. If you're bringing a claim that requires you to establish facts, you get one chance to bring your cause of action before the court and to have it determined. A trial's not a dress rehearsal, and a prayer for relief isn't a first draft. If the respondent's right, litigants will be positively encouraged to claim less rather than more. The reason I say that is a judgment for a breach of contract for £1 bars recovery of any more, because it's coercive or executory, but a simple declaration of liability on the respondent's formulation leaves the doors wide open. So the exclusion of declarations from the doctrine of merger wholesale is unprincipled, and we say ground one should be dismissed. I said that was my final point, and I forgot ground two, but it won't take me very long. Ground 2 is effectively to this effect: is the second claim a different cause of action to the first claim?
Ah, yes, yes.
Oh, yeah.
The point that the master saw some force in. I mean, this turns on things like the article saying the liability remains, for example. That
Yeah,
there is a liability to pay up the shares before forfeiture. Forfeiture doesn't affect that liability, it remains. The only impact of forfeiture is if the shares are subsequently sold on by the company must give credit or must account for the proceeds to the shareholder, or the former shareholder. That's the point there, isn't it?
Yeah, I think so.
I mean, it could be, of course, if the article, you could imagine articles which created a separate liability to pay the amount that had been unpaid on the shares less the amount recovered on reissue of the shares and so on. But it's not. It's more, I mean, is this rate rather analogous to a conventional mortgage or security for a debt?
Yeah.
The debt continues, but the personal recovery will be reduced by what's been recovered on the security.
I think that works. What my learned friend's done is he's very cleverly found another piece in a textbook, again unsupported by authority, saying, look, it's a different cause of action. It's
we'll see. He'll take us to that.
On a
Yeah.
debt.
Okay.
Would you like me to? I mean, I think.
Well, this particular point, no, I think we'll wait, because the judge, Mr. Justice Birss, didn't decide the case on this basis.
He didn't.
Yeah, well, I think we'll let Mr. Lawrence take us to that.
In that case, my lord, I've got nothing further to say.
Thank you very much indeed. Thank you. Yes, Mr. Lawrence.
Well, thank you. There is a certain irony in the fact that my learned friend opened his submissions on this appeal with an allusion to a criminal investigation or something like it in Malaysia, which concerns an individual who may be giving evidence on behalf of Zavarco in a trial that is coming up in a couple of weeks' time, called by me. And by means of that allusion and one or two other points he made, he seemed to have in mind that it might help him to convey to the court that his client has the merits on his side in this in relation to this particular issue. Now, I didn't object, and I don't really mind what my client tells me is a malicious and unfounded criminal investigation being referred to, but of course it's wholly irrelevant. The reason I go straight to that matter and describe it as somewhat ironical that my learned friend places weight upon it is that there has been a broad merit-based evaluation of the defendant's attempt to shut down this litigation herein. The court knows that the application made by the defendant was originally put on two bases. First, there was the ground with which this court is concerned, which raises the rather abstruse points that have been debated already about the concept of merger and so forth. We all agree, it's common ground, and the court will know that if my learned friend's submission that the relevant cause of action has in fact been merged in the declaration that the earlier court made, it's common ground that that is a complete answer to the second action. There is no scope for any inquiry into the underlying merits, whatever. The cause of action has simply been extinguished. There is no qualification to that. That is an end of the matter. And it is that set of issues which is the focus, obviously, of this appeal. But, as the court knows, up to the hearing before Mr. Justice Birss, as he was, the defendant was taking a different point. He was taking a Henderson and Henderson point.
that case, of course, having been decided in the 19th century and then largely put to one side and forgotten about, but then revived and considered closely in more recent authority, and most famously in Johnson and Gore Wood. So, I fasten on that fact, and I fasten on the fact that Mr. Justice Birss gave serious consideration to the Henderson challenge to these proceedings and decided against the defendant. It is important at all stages in consideration of the present argument to bear in mind the potential application of the Henderson doctrine to this type of situation. My learned friend's argument seems to me to be effectively this. He says that if a party goes to court to obtain, and does obtain, a declaration which concerns, you might say, closely concerns, a set of facts amounting to a cause of action, then once that declaration has been obtained, the cause of action merges in the declaratory judgment and, if I may deploy another metaphor, evaporates or disappears.
Yes, it is extinguished.
It is extinguished. It is extinguished. So, that is that, but as your lordships know, and I shall develop the argument, I said that that argument rests on a number of, certainly on one central legal misconception. But my own friend at times in his argument has referred to the underlying policy, the policy that underpins all these principles, all these res judicata related principles, which is a policy involving the benefits of finality in litigation and defendants not being vexed twice and so forth. There is also, of course, the related policy consideration that it is very desirable, other things being equal, that a litigant who brings a certain matter before the court should get every issue that pertains to that matter that needs to be decided then and there, because otherwise one has the risk of duplication and conflicting judgments and so forth. The point with which I open my submissions on this appeal is that all of those considerations do have considerable potential force in this type of situation, in this type of case. A party who chooses to go to court to get a declaration and nothing more than a declaration will wish to bear in mind the possibility that it may be said in subsequent litigation that there were other issues that should have been placed before the court for determination in the first action. Whether the argument that there were matters that should have been dealt with in the first action but which were not dealt with in the first action is a good argument will obviously depend upon the facts of the particular case. And dealing with that argument will require the broad merit-based evaluation that Paul Bingham referred to in Johnson and Gore Wood.
Yeah.
So here, if in this case it could be shown that really there was no good reason whatever for the omission to obtain a monetary judgment before Mr. Griffiths Queen's Counsel, and if it could be said in addition, and this would bolster the defendant's case, if it could be said in addition that the way the matter had been presented to the court on that occasion rather tended to suggest to all concerned that there would be no further litigation, that the matter would rest with the declaratory relief that was being sought. If that could be said, then I would concede, readily concede, that there would be a powerful Henderson and Henderson.
But your point is that that was all gone over in this case.
Absolutely.
And rejected. So
Absolutely.
that this is the doctrine of merger applies, even actually if it may produce on the facts of a particular case, an unjust result.
Indeed.
Yes.
It may produce, I would say in this case it would do if it applied, but I don't need to show that. But one could easily construct a set of facts
Yes.
where it would operate in this type of situation so as to produce a very unjust.
So any sort of policy underpinning of the doctrine is fully met, you would say, by principles such as Henderson and so on.
My lord, I do make exactly that submission.
Yes, right.
Any form of abusive or arguably abusive relitigation, circumstances where the litigant who initially sought a declaration should have sought other relief at the same time, can be addressed by reference to the much more flexible Henderson jurisdiction. Yeah. And this case does in fact demonstrate how my own friend's thesis as to the operation of merger in these circumstances can operate to produce a very surprising result and apparently very unmeritorious result. I don't want to labour anything to do with the merits because the merits don't go to the underlying legal issues. But if I could just remind the court, please, of what was said in the particulars of claim in the first action. Could I take the court to tab 20, page 175?
Tab page 175.
It's paragraph 13 in the original particulars of claim. And the court was taken very properly to paragraph 15, but may I just refer briefly to paragraph 13 and what he said there. At paragraph 13, the pleader refers to a letter from the defendant's solicitors dated the 29th of June 2016, in which a number of points were advanced on behalf of the defendant, challenging the validity of certainly a call notice, claiming that payment had been made by way of non-money consideration for the shares, and at little e, alleging that the claimant would be acting fraudulently by taking steps to forfeit the defendant's shares. And it was that correspondence which underlay what is said at paragraph 15, which the court has seen, but I'll just read it again if I may. As a result of the defendant's letters above, the claimant is at risk that if it exercises its rights without first obtaining declaratory relief from the court, the defendant will wrongly issue proceedings to restrain the claimant or to challenge the validity of its actions, and that the defendant will wrongly allege fraud against the claimant or its directors. Well, one can see that it may be an entirely proper use of the declaratory jurisdiction to obtain legal clarity before proceeding to forfeiture and further steps to obtain money, so as to avoid expensive and burdensome injunction proceedings and allegations of fraud and so forth.
Another reason that people bring claims for declarations is to grab hold of a friendly jurisdiction before they get sued themselves. That's another thing that sometimes happens.
Yes, and if I doubt it can be said we are in that territory.
No, I don't want to speculate about what the reasons were because we've been down that route.
No.
It is, if we're going down that route at all, I mean, it is something that sometimes happens. A declaration of non-liability. That's not what this is. But,
Indeed, you said in order to get into the national court where you think you're going to do best, you strike first and you go for a declaration, and that's the type of situation where a party is engaged in that sort of tactical manoeuvre. That's the type of situation which might be a springboard for quite a promising Henderson application, if the party who's acted in that way to seize the right, what it regards as the most helpful jurisdiction, then brings a second action, possibly in the same jurisdiction or possibly elsewhere. One might then be in the territory of abusive relitigation, which which raises all the merit, the merit-based evaluation that we know is necessary under Henderson. The second point I'll take very shortly is in relation to the argument I'm currently developing, is made good by the order itself, which is later in this tab. It's at page 249. I was always working electronically.
Is this the point about the fact the order itself envisages that
Exactly.
proceedings will or may be brought? Yeah.
Exactly so. And it's a combination of those two things. The fact that the pleading actually took the trouble to explain why the claimant was seeking clarification pursuant to a declaration before taking action, and the fact that the eventual order referred expressly to future proceedings to obtain payment of the debt. It's those two things which almost certainly led to...
Sorry, which is the particular? This is on page 249.
249, my lord. It's the last paragraph. It's paragraph 9. It's related to a possible application for permission to appeal. But what paragraph 9 says is that Zavarco may not take any steps to enforce payment for or forfeit the shares, the relevant shares, pending the outcome of any application for permission to appeal. So that obviously does suggest very strongly that the parties contemplated future proceedings, certainly contemplated obviously forfeiture, but also contemplated
Payment.
further steps to enforce payment. There was another just small technical wrinkle here. If a company is considering whether to forfeit shares, then there may be a case for obtaining legal clarification by way of a declaration before actually forfeiting the shares, rather than immediately then and there pre-forfeiture suing for payment of the debt due in respect of the shares. There may be a technical reason for that. I don't want to develop this or speculate about it too much, but there may be a technical reason for that, because an ingenious shareholder who hasn't paid for his shares might take the technical argument that if the company says takes proceedings to enforce payment for the shares, the company may have lost its right to forfeit the shares because it's accepted that it's going to be satisfied with payment per se. I don't want to place much, if any, weight on that, but I just mentioned it. At any rate, Mr. Justice Birss, as he was, decided the Henderson point in the claimant's favour, very much for the reasons I have just identified. There is no appeal against that, so it is bold for my learned friend to start his appeal on the purely legal point as to the scope of the doctrine of merger by an appeal to the merits. If he had a good position on the merits, he would be developing his Henderson arguments in this court, which he is not.
No, but I must say I took it rather as an implicit admission that the legal point his clients are relying on, I mean, even if it's right, is not at all an attractive one.
He's too skillful an advocate to say that in terms.
Well, that was a subtext.
There were moments in the course of his submissions when he got close to conceding that, he is swift to remind the court, as he reminded the courts below, that in the Indian Grace, the claimant obtained a very modest judgment in India.
Yes.
And was then held to be shut out from bringing a much larger claim.
But of course the problem is, and as the India Grace shows, this is an area of great technicality, which can produce results which almost any reasonable observer would regard as preposterous.
Absolutely. And if merger, I will continue to use the word merger, but before I then develop my argument on the central point of law, may I just make this point about semantic difficulties in this area. Merger is a slightly odd metaphor here, and Mr. Justice Birss, in paragraph 12 in his judgment, mentioned that. He said in passing, his lordship said in passing, well, whether or not that's a convenient metaphor, I paraphrase, it's the one that the law uses. It's a slightly odd metaphor, and there are, as one looks at the authorities, one finds again and again that there are semantic difficulties in this area, and one needs to be very careful about what particular words actually mean. The whole area, in my respectful submission, is better analysed in the way that my Lord Justice David Richards suggested, by reference to the effect of the doctrine of merger. Its effect, where it can be said that a cause of action has merged in a judgment, its effect is what matters, and its effect is simply that a second set of legal proceedings cannot be brought on that cause of action. There is an absolute bar to further litigation on that cause of action. And that, I respectfully submit, is really what this area of the law is, as it were, all about.
Interesting. I was just, I thought, well, I wonder who first used the word merger in this context. But interestingly, Barham Park uses the word merged.
Yes.
Even more interestingly, he uses it in this sentence: the inferior remedy is merged in the higher.
Yes. And one of the words in this, in the cases that are used in the cases in this area, that I would respectfully submit is capable of giving rise to semantic problems, is remedy. What does remedy mean in this context?
Yes.
My learned friend says, and there is the related word relief. What does relief mean in this context?
Yes.
And the two words are.
Well, I think his submission is neither of them matter, because neither remedy nor relief is an ingredient of a cause of action, except in the sense that a cause of action is a set of facts that gives you a right to obtain relief from the court. But beyond that, the relief in question is beside the point.
Well, that's right. He does make that submission, but he did make, as I understood his submissions, he made a second alternative submission.
Yeah.
Because he recognised that there is quite a lot of material in the cases, and certainly in the textbook, which suggests that relief or remedy is an important ingredient of the whole analysis of the doctrine of merger. So my friend made a second alternative submission, which was this. Well, he says, even if the initial judgment that gives rise, is said to give rise to merger, is, quotes, merely a declaratory judgment, in certain circumstances, and in this case, a mere declaration amounts to relief or to a remedy in the relevant sense. And he sought to make good that point by arguing that the declaration in this case was valuable to the claimant, which is true. It was valuable. There was a reason why it was sought. It provided clarification, and it has significant value. It's slightly ironic when one considers the nature of the value that the declaration has. The real value of the declaration is that in the current proceedings, it is binding. It is binding, subject to what may be said on the defendant's side in due course. It is binding on all parties, both parties, to the current proceedings. So if the current proceedings are not, as it were, shut out on the threshold by the doctrine of merger, res judicata operates in the current proceedings in favour of the claimant, because both parties are bound by the declaration that the court has made. So when my learned friend submitted that the declaration was a powerful tool, I think was the phrase that he used, in the hands of the claimant, he was right about that. It was of value. It is a powerful tool, but it's only really a powerful tool now if it can be used by the claimant in these proceedings as the basis of an argument that both parties are bound by the terms of the declaration. And my argument in relation to this concept of relief stroke remedy is that in this context, analysis of the merger doctrine, relief stroke remedy means a judgment of the court which is immediately enforceable. The paradigm of such a judgment will be a monetary judgment of some sort.
So, sorry, just give us that proposition again. So the doctrine applies.
The doctrine applies
Just give me a second.
where judgment has been obtained on a cause of action
Where judgment obtained
on a cause of action it so as to provide, or in terms that provide, the claimant
well for a remedy.
for a remedy that can be immediately enforced.
Well, that can be enforced.
Yes.
It may be stayed for a while, but that can be enforced.
Subject to stay pending appeal and so forth,
Or it might. Yeah, exactly.
can be enforced.
Okay.
And the paradigm, obviously, of such a judgment is a monetary judgment, which amounts to the, let me put it colloquially, amounts to the court saying to the losing party, pay up. You have to pay the quantified sum of money to the successful claimant. And if you don't, the successful claimant can invoke the coercive powers of the state to enforce payment. And the core of my argument is this proposition, that when a claimant who possesses a cause of action in the relevant sense goes to court, proves the facts which are the necessary elements of the cause of action, and obtains a judgment of the type I am currently contemplating, that is when the doctrine of merger applies. And it makes perfectly good sense for the doctrine of merger to apply in those circumstances.
Yeah. Right.
Because the lesser right, which is the right to have access to the court to prove your case and to seek to obtain a judgment, has been replaced, I would rather say replaced rather than merged with, has been replaced by a, if you like, superior right, which is the right or the set of rights that are created by the judgment of the court.
Right. So the short point, therefore, is that it doesn't include judgments for declarations.
Exactly, my lord. And this then, I think it's probably makes sense if in the short period before the short adjournment, I at least take the court to Spencer Bauer and begin my consideration of that textbook. It is this central part of my argument which really prompts quite an interesting reflection set of reflections as to how the common law is made. The problem that the court has here is that faces here is that probably the leading textbook, I think I can say with confidence, the leading textbook in this field unequivocally supports the proposition for which I contend. But as I think Mr. Justice Birss said in course of argument, the difficulty is that there is no footnote, which cross-refers to an authority. It might be quite an antique authority, but there is no footnote. And as the...
Well, I think it goes a bit further now. There isn't a footnote, but there isn't it's not reasoned. I mean, it wouldn't matter. I mean, given that there isn't an authority, one wouldn't expect a footnote identifying an authority. Yes. But what would be helpful is for the author's reasons to be set out, because that, of course, could have an impact on the development of the common law. That's as I see it. Now, there are some footnotes, actually.
Yeah.
But we don't, I think, have the footnoted passages. So let's go, if we may, to it now. So this is tab 14.
Tab 14. May I ask whether, I'm sorry to arrive late yesterday afternoon, whether the report received...
We did, thank you. This is your archaeological researches. Yes, certainly.
Yes,
Certainly,
I'm very glad you did that, and it was one of the things I was going to raise, was whether someone had looked through the earlier editions to see how far back this goes. And
Yes, well,
apparently it goes back to 1924.
It does. I'm better informed about Mr. Spencer Bauer, who was born in the 1850s, died in 1928. So,
Right. This was his-
sadly, but
His swan song.
this was his swan song. Of course, as the court knows, he wrote, I think, at least
Lots of
3
books.
different textbooks on
Yes.
matters pertaining to estoppel,
Mm.
which are still, to his credit, which are still cited. They've been much developed by subsequent authors. And just so the court knows, what I found in my burrowing in the Inner Temple and Lincoln's Inn libraries is that there are 5 editions in all of this textbook. The second edition did not come out until 1969. This is the second edition that I've drawn to the court's attention, which was written partly by Sir Alexander Turner, who was a judge of the Court of Appeal of New Zealand. And then there are 3rd, 4th and 5th editions coming out in the mid-90s, I think, then around 2009, and then very recently, all partly written by Mr. Justice Handley, who is a judge of the Court of Appeal of New South Wales and is a well-known and distinguished jurist. So we have 5 editions, and I have checked the same proposition in substance appears in all 5, and it does. So the extract that is in the authorities bundle obviously has been taken from the most recent edition, and if I could introduce it by taking the court to page 279. I had thought that I had placed the index to Spencer Bauer and Handley in the bundle, but I don't seem to have done so. But if I could take the court to page 279, if I could just introduce the textbook in the following way.
Sorry, page 279.
I'm sorry, I'm using it's page 248 of the bundle, so using the bottom right-hand pagination. Page
Oh, yes, sorry. Yes, sorry.
279 is the internal
Tuesday,
text.
yes, I turned the wrong page. Yes.
And if the way the book is structured works is as follows. Part 1 of the book, which runs from chapter 2 to chapter 18, is headed Res Judicata Estoppel. And then part 2, which is much shorter, which starts at chapter 19, is headed Merger in Judgment. I just mention that because the taxonomy of these various principles, as considered by Lord Sumption in the Virgin Airways case and elsewhere, is itself quite problematic. And I'm going to make a submission about that and about the Virgin and Clark cases in due course. At any rate, this part of the Spencer Bauer and Handley book is unquestionably considering the merger doctrine. So if one starts at paragraph 19, the text says this: Res judicata has a twofold operation. It prevents the parties disputing the decision and bars a party who obtained relief from seeking it again. Those, well, I'll read on and then develop my submission. Then a passage is cited from Lord Justice Diplock's judgment in Thoday. Might I ask the court to read that? The critical sentence in that passage for present purposes, I think, is this. If the cause of action was determined to exist, i.e. judgment was given upon it, it is merged in the judgment. And the court may conclude that it is necessary to consider carefully what is meant by the phrase judgment was given upon it. My submission is that judgment is given upon a cause of action if the court enters judgment for the claimant, typically for a monetary sum. The position may be less clear-cut, but it may well be that judgment can also be said to be given upon a cause of action where the court makes an injunction or grants an injunction. Again, that is a coercive order in the sense that obviously the successful litigant can enforce the injunction by committal proceedings and the usual means.
And is it a relevant consideration here, perhaps you're coming to this, that declarations are, on any view, a rather peculiar form of relief, in the sense they have special principles applicable to them. I mean, they're always discretionary, the court won't grant them by consent, as you say, I mean, they have no immediately coercive consequences, although of course they can ground issue estoppels and cause of action estoppels. So, I mean, that may be a reason for saying they occupy a kind of halfway house towards the full nature of a judgment which can actually result in a merger.
Exactly. That is exactly how I put the argument, my lord. And when one, I'd be critical of the metaphorical term merger, but perhaps I should withdraw the criticism because it does have has a function here. When one thinks of the concept of a cause of action merging with a judgment, that concept makes sense where the successful litigant obtains a judgment which is immediately enforceable. It just makes rather less intuitive sense where the only thing that the successful litigant obtains is a declaration, which to a greater or lesser extent is consistent with that litigant's arguments as to the correct analysis of the legal state of affairs. Rather odd to think of the underlying cause of action merging with what I would characterise as a mere declaration. At any rate, well, I probably need to come back to this, to the phrase judgment was given upon it when I asked the court to look at one or two authorities which use similar language. The passage here in 19.01 then goes on to draw a very important distinction. And if I could pick up the text about 10 lines from the foot of the page, please, one sees this: a plea of former recovery. And I shall demonstrate that the authors use that term as interchangeable with merger. A plea of former recovery is distinguishable from one of res judicata estoppel. And then this is critical. The latter prohibits contradiction, the former reassertion. In cases of estoppel, what must not be controverted is a proposition of law or finding of fact. In cases of former recovery, what is not allowed is a second proceeding for the same relief. Again, one sees that word relief and one recognises its importance. Arnold established that the merger rule against double recovery is inflexible with no exception for special circumstances, and Chamberlain is to the same effect. That I think is an Australian case. An important distinction is there drawn between doctrines that prohibit contradiction and the doctrine of merger, which prohibits reassertion. that distinction, in my respectful suspicion, needs to be borne in mind at all times when considering the authorities in this area. My lords, I see the time. I'm going to go on to compare if I may, the text in the second edition, which contains a slightly more elaborate treatment of the distinction between contradiction and reassertion that I've just identified.
All right.
Would it be convenient to do that?
Yes, certainly. We'll resume at 2 o'clock. Thank you very much.
Does the court have the printed out? Because I do have copies.
Well, what we've got, what I have got is, at any rate, are pages. I think it is probably yes.
Someone has failed to reach me, so if you've got a spare copy, I'd be very happy.
Right.
I do.
This is from the second edition.
It's from the second edition.
And it's pages, whatever it is. Yes.
Do we have
355.
Do we have the relevant pages of the first edition there, guys? It'd be quite interesting to see that, given that this is the earliest reference.
But my learned friend, I think he was joking, suggested to me that the first edition clearly contained material that was fatal to my case. So it doesn't. But I think between 1 and 2 o'clock, my lord, I will. I'm sorry not to have done it before. I'll try and get that material and show it to you.
I mean, because if it's not in you say it is in the first edition. Yes, it's a question of what is Spencer Bauer and what is Sir Alexander Turner.
Well, indeed. Well, in fact, the passage that I'm going to go to at 2 o'clock is Sir Alexander Turner, because it elaborates what is in the first edition. So I will get the comparison.
Well, at some point, anyway. Thank you very much.